no such statement of law available except those two judgments where the statement of law is for the purpose of knowing the antecedents of the candidate, a specific, concrete purpose to be achieved. So unless we say this larger purpose will be a specific, concrete purpose, we may have to look at it very differently. But before I dilate on that, I proceed on the footing there is such a right available. And therefore, anything which may have a bearing on the citizens' expression of participation in democracy is a value, is an important value. And for that, it must know everything which must come to the aid of the citizen to participate. So therefore, disclosure, information is integral to that expression dimension. The other value which the scheme seeks to promote is confidentiality of the contributors, and which is an enabling part of the scheme itself. So the enabling part of the scheme is confidentiality of the contributors. It doesn't make a difference between corporate contributors or any other contributors. The scheme treats all contributors equally. It doesn't pick and choose between contributors. So that value of the contributor's confidentiality, and the more important value with the learned solicitor pointed out, that moving away from a cash, black money, unknown sources scheme to a relatively regulated scheme, and which serves the public interest of taking a first or a second or a third, whatever step one may call, towards ensuring a greater credibility in the funding process. We look at the question whether a nexus, a quid pro quo will have an influence which is hostile or adverse to fundamental values of democracy is a different issue altogether. Because that issue, in my understanding, which may go into a political party funding equality of opportunity, or whether there should be no political party funding at all. These are larger debates. You want to look at what you as Supreme Court has been grappling with this question. In Arizona case where the court says a matching contribution from public funds to publicly financed candidates. The court says that that places an undue burden on the freedom of expression. So all those things are in the larger political domain. Therefore, the equality of opportunity, free and fair elections linked to that equality of opportunity and level playing field, all those concerns, in my understanding, would require an analysis and evaluation which brings in norms and new norms for consideration and acceptance by the community and through parliamentary debates. Therefore, I don't think that aspect would probably be even invoked for the purpose of entering and looking at the three values which are in competition in this scheme. The public interest value, the confidentiality of the contributors' value, and the citizens need to know the information regarding who contributes to whom. Now I ask myself a question. So how do you evaluate or balance these apparently competing, use the word apparently competing values? Yeah, I don't need to tell you lots about the three basic principles of proportionality, that there must be a legitimate purpose of a law, and it must have a rational connection with the object. And the next stage is that what the law does is must be to seek an object, must be least restrictive of all equally effective means. So the balancing test in this context would mean applying all this, and in a very fact-involved situation like this, it would mean a cost-benefit analysis, which would bring greater costs in terms of effectiveness, bringing in effectiveness, credibility, purity, and which would not do that, and what kind of benefits will flow from that. That kind of a cost-benefit analysis, not necessarily in the economic or the financial terms, but in an empirical terms. So in empirical terms, I don't think that kind of an empirical analysis has been made available to the court, and that has not been the scope of discussion before the court. I'll just give an example, because this kind of a cost-benefit analysis, which often comes in the proportionality domain, I'll give a reference to those cases. For instance, in Germany, we had in the province of Bavaria, crucifixion was permissible in public schools. So in a complaint given by those who did not believe that, the Constitutional Court of Germany said that there are two competing rights. The right of one set of people to say, I would not believe in this. The right of the majority of Bavarians who believed in display of crucifixion as a part of either a religious symbol or a cultural symbol. So there is balancing between two sets of freedoms. One a negative freedom, and another a positive freedom. This kind of balancing always comes in when we have very important social concerns in conflict. But some of those balancing can happen at a conceptual level. But very often, even at a conceptual level, it happens. Some right to the other yields to the other right. One right yields to the other right. So the yielding of it should take place under what criteria, what norms. That may differ from the right in question. When you're talking about this particular aspect of evaluation and the cost-benefit analysis of public funding or funding from any sources, public versus private, do we have all that kind of, an empirical analysis and the norms which can guide the court? We say, this is how we apply this norm. We apply this norm and find this is faulty on that norm. On the other hand, if the court were to call upon to create a norm and say that any funding from any source, more particularly from a corporate source, intrinsically is an evil dimension to it, then the court is called upon to create a norm. That's why I said in the footnote that we are not entering into the domain, but even indirectly, if that idea influences the analysis of the court, there could be this problem. I think that idea has been brought in to probably color the debate, saying that this issue is intrinsically an evil matter, that therefore keep that in mind, therefore disclosure will be very, very important. So the nexus between that aspect and the disclosure sought is somehow sought to be very subtly brought in, and I say you'll also keep it in mind that subtle connection we have to probably sever, because we're only looking at the three competing values, diverse from all this, and say therefore is the court called upon to apply a proportionality test in this at all, if at all, then how would you go about doing that? I have my brief submissions. It is at volume 2. Like any reporting, the Warren Benn reports, it says, the attorney says citizens do not have a right to know. So, I don't know where I said it in the submission. Let me read it out. Your Lordship, sir, could have volume 2?
Yes.
I'll quickly run through it, and then one of the aspects I wanted to probably also address that in the context of 19(1)(a) and the Association of Democratic Reforms and PUCL.
Volume
and
2 of,
Your Lordship, please.
Volume 2 is
Volume 2 is a separate volume.
Compilation of Union of India.
Convenience compilation also find it.
of the convenience compilation.
There's a convenience compilation.
Compilation of judgments and documents.
I'll be in the course of reading the submissions, making
Mr. Attorney, we have read the submissions. There's something that you want to highlight in particular in the submission?
Yeah, as I read a few parts of the submissions, I thought in my notes I kept what probably I would be talking about. Lordship, kindly look at paragraph 5 of this submission, because the first 4 paragraphs like a kind of an introduction to So we don't have to go into the larger question of how the emanation of political parties and how, as a 19(1)(c) associations, it comprehends a variety of aspects of a political party, its supporters, its believers, ideology, and so on and so forth. Therefore, when a contribution to a political party comes in from either from a corporate or any other individual, it did not go under the color of a mere quid pro quo dimension. A person who supports a free market economy, and I find a free market economy which is propagated and supported by a political party, it will have my support. So beyond ideology, there are other considerations which bring about affinity between a contributor and a political party. So, and as I saw the tabular statement of all those contributors, it has all those small scale industries, a wide range of small scale industries. And we can't be fitted in to the quid pro quo dimension at all. That's why I said this scheme doesn't talk about a particular class of contributors. So I would probably be right in saying that the scheme is a regulatory within the broader concept of regulation of Article 19(2). As while an argument has been raised that the right to know 19(1)(a) cannot be subjected to any restrictions under 19(2) as they stand, an argument has been stated in the written submission, though not has been explained as how it really can happen. So I proceed on the footing that in principle, the concept of regulation can flow from any one of those 19(2) to 19(6). If one is right in saying that derivative rights or penumbral rights, the way of looking at a right can be seen beyond the text of the right. If that is possible, I suppose, implicitly, and if it's also correct in saying there can be no right without a restriction, and I'm sure no court will say that I will postulate a right, but I will not visualize the restriction on the right.